Hi again, everyone. It's Ryan Carroll with the Hearth Patio and Barbecue Association Government Affairs team back with you once again. In our very first video update, we discussed the California Restaurant Association versus the city of Berkeley and the decision of the Ninth Circuit Court of Appeals to overturn the city's gas ban as being preempted by the Energy Policy and Conservation Act. There are still pending appeals in that case, so we're waiting to see how that plays out. But as we've covered in other government affairs updates, the multifaceted march towards all-electric construction is certainly not limited to cities in California. New York made news earlier this year when it adopted a state budget eliminating natural gas infrastructure and appliances in most new construction. This action has led to a legal challenge in New York that I'm going to ask Karen Arpino, the executive director of the Northeast Hearth Patio and Barbecue Association, to discuss with us. Karen?
Thanks, Ryan. Hi, folks. As Ryan mentioned, in May of this year, the New York legislature passed a fossil fuel ban for all new construction in buildings less than 7 stories to begin on December 31st, 2025. There were several bills in the New York legislature for forced electrification, but there was some pushback from unions and trade associations, including the Northeast HPBA. As a result, the New York legislators decided to wrap the ban into their state budget. They really wanted to be the first state in the country to ban fossil fuels. The budget had to pass, so after over a month of operating without one, they finally passed a budget with fossil fuel ban language included. There are lots of exemptions in this ban. We actually didn't think we'd have a lot of legal leverage because of all the exemptions, but a group of trade associations started talking with the same team of lawyers who won the suit in Berkeley, California. And we discovered that we may have even better standing in New York State than the Restaurant Association had in California. Even better, with the ruling in Berkeley, a precedent had already been set in federal court. The ban's illegal based on the Federal Energy Policy and Conservation Act. It's the EPCA, a longstanding federal law establishing a national energy policy. So last month, we decided to join the suit as a plaintiff along with 10 others, all trade associations and unions, as well as one independent oil seller. We asked our New York members and HPBA to help with the funding for the suit, and they all really rose to the occasion. Our New York members funded the suit in less than 2 weeks. Our lawyers filed the complaint on October 12th, and we were off to the races. In fact, we even got funding from dealers in other states who are hoping that we win the suit so this type of ban doesn't end up in their state. Within hours, the story had been picked up by both regional and national news. It's really very exciting.
Thanks, Karen. Yes, exciting indeed. And it's worth noting the HPBA, along with several other national trade associations, took part in the Berkeley case through the amicus brief process. So it's great to see Northeast HPBA be involved at the earliest stages of this case. And as we see this legal challenge likely be taken up in more and more states, there's a very real prospect for split decisions between the district courts, which could see this battle on a path to the U.S. Supreme Court. So this was intentionally a very brief background on the New York litigation. To hear more, Karen and I are going to be on an upcoming podcast with the FireTime Network and would love everybody to listen as we take a deeper dive on this issue. Thanks, and please be on the lookout for more content from us soon.